Hi, this is OC estate plan lawyer Michael Pevney, and I do estate planning for families. And in this video, we are going to talk about what happens to your kids that are under 18 if you pass away without an estate plan. But before that, if you have any questions about this topic or anything else related to estate planning, you can set up a time to meet with me for free by going to ocestateplanlawyer.com. So what happens to your kids that are under 18 if you pass away without an estate plan? The simple answer is that a judge decides. A hearing will be held, and somebody who wants to come forth to be a guardian will be appointed by whoever the judge thinks is most appropriate. The best way to prevent that and to have some say into who takes care of your kids when you pass away is to create a complete estate plan along with nomination of a guardian and a revocable living trust. And when you do this, you create two important jobs. First, you nominate a guardian, and this is the person that's going to act in your place, that is going to act in place of the parents. And the trustee is going to be the person that essentially controls the estate and controls the money after you're gone and how that's doled out to your kids that are under 18. Now, when selecting a guardian, there's always some important things to think about. Obviously, it needs to be somebody that's very close to you and that you trust with your kids. They should have a really good relationship with the kids. They should be responsible with money and have a stable family situation. Sometimes it's a good idea to have a single person be the guardian, not necessarily a married couple. So for example, if I wanted my sister to raise my kids after I passed away, I might not have my sister and her husband be listed as the guardians, because what happens if my sister passes away? I don't necessarily want my brother-in-law raising the kids alone. Or if something could happen to that marriage and they get divorced, that's going to add a lot of complications. So a single person as the guardian can be a good idea. Now, that's not to say that you shouldn't have backups. You should always have backups to who your guardian is going to be. Also, a good thing to think about, what is the health condition and maybe the age of that guardian? So we often want the grandparents of the kids, our own parents, to be a guardian. And so if a grandparent is 70 and the youngest kid is 2 years old, they're going to be the guardian until they're 18. So in 16 years from now, 70-year-old grandparent is going to be 86 years old. So is that going to be a good idea? Always something to think about. And then the other important job that we choose is the trustee. And when we talk about a trustee, we're talking about somebody that's very responsible with money. They might not necessarily need to live as close as the kids are or have quite that close emotional relationship with the kids as the guardian does. But it's important that they be responsible with money and are willing to carry out your wishes as you set forth in the trust that you create. So that is what happens when you pass away without an estate plan. A judge decides, unless you take steps to avoid that by appointing a guardian and a trustee that you create in a trust. So just as a reminder, if you have any questions about this or anything else related to estate planning, you can set up a time to meet with me for free at ocestateplanlawyer.com. Once again, this is OC estate plan lawyer Michael Pevney. Thank you for your time and thank you for your attention.